Welcome to the Divorce Do's and Don'ts show. This is the show that covers all phases and aspects of divorce so that you can avoid common, costly, and sometimes permanent mistakes and have a smarter, saner, savvier divorce. So without further ado, I would like to introduce our wonderful host, Lisa Decker. Lisa is a certified divorce financial analyst, and she is a real estate collaboration specialist in divorce. Lisa is also the CEO and founder of Divorce Money Matters, and the organization that brings you this wonderful show, Divorce Town USA. So Lisa, what do we have to look forward to today?
Well, thank you so much, Marcella. Marcella Kripe, my dearest executive assistant and producer of the show. We could not do this without her. Today, we have a very special episode about divorce and special needs. This is an extremely important topic. Any couple with either a spouse or a child with special needs will face unique challenges to the process, and we're here to help. Our guests today are Mary Ehlert and Georgia Lord. And Mary Anne Ehlert is a mother, sister, and daughter to her loved ones with disabilities. This is a woman who has a lot of experience with this, and she's going to really help us today to understand those unique needs. She is highly regarded as a specialist in working with families of individuals with disabilities and the elderly, and speaks at conferences, hosts webinars, and runs virtual training on future planning. She often has provided life planning testimony to support the children with special needs care in court proceedings. We are also, as president and founder of Protected Tomorrows and a partner of Forum Financial Management, Mary Anne has served as vice chair for the National Disability Institute in Washington, D.C. She currently serves on the board for CDLS National Foundation, and I'll let her tell you more about that, and the Special Olympics Illinois Foundation Board, and the advisory board of Tales for Life, and the advisory council of Integrative Touch. This is a very busy lady. We're so excited to have her here today. And Georgia Lord, an esteemed attorney who is a wonderful Divorce Town member with the Decatur firm of Radford and Keebaugh. She offers both collaborative and conventional family law services to both traditional and non-traditional families. She also represents clients in public accommodation with disability rights matters. So ladies, I am so excited to have you on the show today. We're going to start off by letting Mary Anne give us her presentation, and Georgia is going to add commentary from the legal perspective. So we're going to have a really great intermingling of these specialties today during our show. So I'm going to turn over everything to Mary Anne and let her start us off here. Marcella, would you mind taking me and yourself off camera, and I'll just be in the background adding commentary right now.
Absolutely.
Thank you so much.
Okay, thank you very much I'm excited to be here. It's a topic that is near and dear to my heart, special needs as well as divorce. And I am a divorced mom, but I will tell you a little bit about why I do this. So I had a sister with special needs. Her name is Marcia, and she's why I do what I do. She was 4 years younger than me. She had cerebral palsy, and she taught me that she wanted independence, that she wanted a happy life. My parents wanted her happy life too, but they wanted to keep her in a cocoon, and I wanted to expand her life, right? So we had this interesting topic of conversation a lot of times. But as time went on, I realized that my parents had done the best planning they could, but they didn't understand a lot of the intricacies of things we needed to do. And so that's how I got started in working with families. Over time, I also have 3 stepchildren, all with some disabilities, and it's the middle son with significant disabilities. So I've not only learned it from a sister's perspective, but also a mom's perspective. And then both of my parents became disabled. So I really got experience in being a caregiver and looking up. So I always say it's up, down, and around when we look at anybody, and how are we impacted. So that's basically how I got started. So I thought I would start with when I'm sitting with families, and many times when we're doing financial planning, someone comes up to us and we're doing life planning and financial planning, and we see a lot of couples because having a child with a disability, be it developmental disabilities or mental illness or whatever it may be, it's really stressful, right? And so sometimes that stress on a relationship is beyond what the relationship can bear. And so we get involved sometimes. We try to always have the mom and the dad or the couple in front of us having this conversation, because we find that there's two kinds of couples. One couple that really wants to make sure that that child is got the best they can have no matter what. And that's always what the parents' goal is. We always start with the conversation of what's the best thing that can happen here. And most of the time, very high percentage of families start with agreement. But then as we get down into some of the other areas, we find the disagreement. And I'm hoping Georgia can give us some insight today about how we deal with some of those, right? But I will tell you one of the disabilities we talk about a lot is capability, because a lot of times we will find one parent being the custodian and the other one being the one who's going to work and making a living, so that the mom or dad or whoever's a stay-at-home parent can be there for that child. And we find many times one of the parents has given up their ability to focus on their career because this child has taken a lot of their time. So the one who's a stay-at-home parent or has the majority of the responsibility tends to be more in the middle of the struggles with the child and the capabilities or lack of capabilities. And the person who's working isn't there every day to see it. So we sometimes will see one parent say, well, when I'll ask the question, what's the future look like? Do you think that child can drive? One will say, oh yeah. And the other one will say, what were you thinking? He'll never drive. So some of it is about that. Some of it is about control of the future. So as we start to put the life plan in place and say, what does that look like? Sometimes both parents want to control what the future is going to look like. Is it can they work? Are they going to be able to drive? How are we going to find the services for them? And sometimes both parents are trying to struggle through that. And then thirdly, the true understanding of the needs. Many times, especially if the child's young, they don't know yet what's going to happen. They don't understand some of the things we're going to talk about. And so we're helping them understand that. And there's disagreement as to what kind of school is needed, what kind of backup will be needed for that child. Can each individual fulfill those roles? So those are some of the conflicts and discussions that we have. All right, so
thank you for that, Marianne. I wanted to just jump in if I could really quickly and ask Georgia about that, because that is one of the biggest things she said she sees in a high conflict divorce with special needs, is that parents don't agree what the special needs are, or maybe the severity of them. So Georgia, at least in the state of Florida, can you help our audience understand what a judge might look for when determining what those are? And
Sure.
then Marianne's going to give us some more.
Mm-hmm. Sure. I worked for Fulton Superior Court for the family division for a total of 6 years. And of course, I've seen a lot of family law cases on my own as well. And it is fairly common. Of course, special needs, there's a huge spectrum. All of us have things that we're better at and worse at, and children, of course, are no different, but some have greater needs than others for some extra supplementation. But it's not at all uncommon for one parent to be, there's nothing wrong with my kid, and the other one to be, oh no, we need lots of special services. And so what the judge may do is to look at the evidence, to look at things like, what does the pediatrician say? What does the child's teacher say? It may be, sometimes they may get advice from an expert witness of some type. There may be a guardian ad litem appointed. They may want to just see how the child has responded to different situations. But one of the things that the judge often looks at is, how did the parent go about investigating this question? Were they able to, it's not, okay, listening to what the experts say. It's not that parents are expected to blindly accept whatever an expert tells them, but there is value in a parent being willing to listen to it, to not turning away from it, and asking good follow-up questions, investigating it themselves, and seriously consider what somebody with serious credentials has to say. But also, there's another pattern I've seen is that sometimes a parent will get really into a treatment plan that's outside the mainstream, like, and they may be really determined that the best treatment for their child is this one that's sort of offbeat. Well, that may not go over as well with the judge as one that's more conventional.
Thank you.
Excellent. Thank you, Georgia. And Mary Ann, maybe you can talk about some of those too, and how we can marry the two to have a lesser conflict divorce whenever possible.
Right. So we tend to approach it by starting and asking certain questions and asking each person. And sometimes I will do it independently so that I get the view from each parent. And since we're looking at it, and so we are looking at it from a perspective of money, but we're also looking at a perspective of the emotional attachment and the needs and the fear. So there's always fear. And I start with the conversation of what's the best thing that can happen, as I said. And I usually hear, if we are playing Family Feud, the number one answer is I want my child to be happy and I want them to be safe. And I'll hear that from both parents. But how that translates into the details and the nitty-gritty of what needs to get done is always the challenge. So the first thing we try to do together with the parents is to create the vision of what they want. Where do you see your child living into the future? And again, if some of these things are so far away, and some of them we're dealing with parents who have a 17 or 8-year-old who's in a transition program in school, and they're coming out and they're starting to think about what's next. And they've already gone through some of those, they've gone through all the medical things. And now we're, helping them maybe think about benefits and what benefits might they get, which we'll talk about. But we're having this conversation of where do you see your child living? Many times we hear one parent saying, well, they're going to live with me for the rest of my life. And the other parent recognizing that's probably not reality, or vice versa. And so we try to have that conversation of what's really in the best interest of the child on a consistent basis. What are their medical needs? Understand that. Understand what are their recreation needs, because a child isn't just about their medical needs and what the parent can do, but it's what the society can do and what recreation programs and what make that happiness. We focus on that. Is it recreation? What triggers things that we have to worry about? Education. And education isn't done at high school in the special needs world anymore. There's programs all over this country that are college programs. So we're talking about things, 20 years ago, we didn't have conversations about college. But now I have many families who have their child in some kind of transitional education, which is 2 or 3 years, and they come out with the ability to do more than the parent ever thought they could. So we create that vision and then we quantify it, because that's where we can get down to. Once we have the vision created, and it's a very detailed vision of where's the child going to be in different stages of their life, then we can say, how are we going to pay for this? And we talk about benefits and what the benefits might or might not do, and how much has been saved and how much is insurance in place. And, there's a lot of instances where health insurance can be maintained for the life of a child on the parent's records. We want to understand all of those details. Life insurance, how much is going to be needed. And through this process, what we're doing is we're designing the life just like a person would for their own retirement plan. We're building this life plan for the child and saying during the parent's lifetime, what are they going to have to fund while they're working? What are the parents going to fund when they retire? And then what are they going to have to fund when they both pass away? So there's 3 different stages. And we're looking at both and trying to build a cohesive care plan that is funded and have some agreement. Where we get into a lot of disagreement is government benefits. So the one thing we hear the most is, well, I can help fund support the child, but when benefits come into place, I won't need it because the government will pay everything, won't they? And the question is absolutely not. The government is going to pay certain things, but when we're working on these cases, we will look and make sure both parents understand that there are limitations, and we have to understand the child's limitations relative to this. because SSI is $841 a month, but it won't be if the child is subsidized by parents. And so we have to be very clear as to understanding the medical needs of the child so that we could prove if they don't have SSI that they can get it. What will happen then, it gets even more complex because the child becomes eligible for something called DAC, which is a disabled adult child program. So the child is going to become eligible for something on the parent's Social Security record. So we actually ask for Social Security records for each parent, and we put a plan in place at that time to say, this is probably what could occur. And it's going to depend upon each parent and when they apply for their own Social Security, because when they do, the child goes into a whole different program where they become eligible for Medicare and other programs. So at 18, they become eligible for SSI and Medicaid. And then when the parents retire, the child starts to become eligible for Social Security on the parent's record. And when they do that 2 years later, they get Medicare. It's complex. It's complex for everybody. Social Security is complex for everybody. And all of a sudden we throw in this, we have to understand all of those pieces relative to not just the child and the ability to have enough information to get these benefits for the child, but also describe in our cash flow planning that that's not enough, right? If they're getting $841 a month, there's so many things that the child still needs over and above that. No one could live on $841 a month. And even if they're getting DAC on a parent's record, let's say of $1,200 a month, we call it retiring for three. We got two people, parents, and we got this other person that both parents have a responsibility to help. And helping them understand that has always been an interesting journey because we need to convince both parents and show them with numbers what this child needs. And that's where that life care became so important, that life care plan, because government money is not going to pay for anything above basic support. And if we want the child to have a full life, which is where we started, they want them to be happy and have a full life, we've got to get back to this point of making sure that that's all funded. And so now you've got these parents who have this, they have to do more planning than the average couple divorcing, because they haven't done their special needs trust, which is how we save for a child with special needs. If they haven't done that, we have to put that into the mix too, to say, how do we make sure that they have these legal documents done? Now, every family needs the trust on the left. That's called a third party special needs trust. It's how we as parents put inheritances, and when we save, we create the trust on the left. But in the world of divorce, the trust on the right becomes very important, right? So when we looked at benefits a few minutes ago, what matters once a child is 18 is the child's assets and income. That's what the government, that's what Social Security and Medicaid look at. What is the child's assets and income? So we care about those because SSI might be a small dollar. Medicaid is the big dollar. Medicaid is the program that's going to pay for future care. It's going to pay for getting into programs. It doesn't pay 100% of the care, but it gives them some basic support. And so the rules around SSI is the child can have a home, a car, a prepaid funeral, $2,000, and an ABLE account. That's it. House, home, prepaid funeral, $2,000, and that ABLE account, and the special needs trust. The special needs trust is never considered theirs. The trust is for over and above that. Parents fund that. How do they agree on that funding? It all goes back to that life care plan that we built and say, in the life care plan, how much is going to come in from the government and how much do parents have to do? And it's an understanding that the number is much bigger than that, what the government is going to pay. Now, the complexity comes here is that when we start to negotiate what child support is going to look like, child support, when a child is under the age of 18, belongs to the custodial parent. So let's say mom is going to get some child support and dad is funding it because he was the worker and mom was the caregiver. And all of a sudden we're starting to talk about child support. Child support is payable to the mom until the child is 18. Child support in many cases is awarded for the lifetime of that child.
No, not in Georgia.
No, in some states.
Not in Georgia.
Right, exactly.
It doesn't go beyond graduation from high school or, yeah, 18, yeah.
Okay. So in most cases, but in some cases, we do have across the country, parents understanding that they need to fund this child. And when we're doing that, the child support, if it's paid to the mom, it's really the child's. Once a child turns 18, child support is considered the child's income. If the child support is paid directly to the mom, Social Security will come back and say, well, child's income, we probably don't need to help them so much. So what happens is the child support must be paid in order for this to work. The child support belongs to the child. That trust on the right, the supplemental payback trust, is a trust for money that belongs to the child. We're allowed to fund it, put the child's money into that trust. It's for the child's supplemental care until they pass away, and then the government gets reimbursed if from Medicaid spent, if there's anything left. Now, in reality, when we're setting these up in divorce, the child support is ordered by court order to be paid to this payback trust. Mom is the trustee, dad is the grantor into the trust to fund the money. Dad's paying the child support instead of to mom now into this payback trust, and mom is using the child support out of that trust for the benefit of the child. Then the government benefits stay intact. The SSI stays intact and the Medicaid stays intact. If we do it any other way, benefits are at risk. So it's really important to understand. I just got through a case I'm working on in Maryland where dad said, well, you know, I'm going to pay child support and I'm willing to pay it up until the benefits kick in. Once the benefits kick in, I want to drop the amount of the child support. But this particular case, the child is in programs where that SSI check, and this is what's important, if the child is in a program, the SSI check gets turned over to that program. It's not used directly for the care of the child. It is used for programs the child's in many cases. So we still have the same financial need as we go through that process and say, where are these government dollars really going to go? And they're going to services. We still have all the clothes and cell phones and any other expense a child might have, extraordinary dental care, extraordinary medical care that is not paid by the government. So it's important when we do that. Yep.
Perhaps this is a good point for me to just note that, of course, in many families, the child may have some special needs that are not as significant as may come up in some of the ones that involve very extensive trust planning. But what do you do if or maybe the family can't afford that kind of trust planning? I know Mary Ann might say maybe they can't afford not to, but at any rate, just a few thoughts on what do you do if you have a child that you think is going to need some extra services along the way? My big piece of advice I have on that is in your parenting plan or in your child support paperwork, in your settlement, try to set up clear rules for what types, how each type of expense is going to be paid. Education, medical, maybe figure out whether childcare is going to be, when it becomes education, that kind of thing. Are you going to have one parent pay it? Is it going to be divided between the parents? And the thing that I really would encourage people to avoid or to be very, very careful about is having a situation in which one parent is the one making decisions regarding a certain area and the other parent is stuck in whole or in part for paying for it. So if one person gets to decide public or private school, but doesn't have to pay any part of that expense, that can encourage them to put the other parent in a very difficult position. So it's good to consider all the types of different things that you can anticipate may come up, which that will need to be paid for, and decide how you're going to divide that. And the other thought I have is that at least under Georgia child support, it really can make a big difference whether you factor certain types of expenses into the child support number or whether you make arrangements to pay them separately. Because for most kids, often it can vary a lot from year to year. If you set a child support amount when a child is very young and has very expensive childcare needs, that may mean that you end up with higher long-term child support payments than if you instead agreed to have have a division of childcare expenses. So depending on whether you're paying or receiving, that's just something to think about.
Yeah. Those are really great points. Thanks, Georgia.
Mhm.
Okay, so I said as many states, child support can be payable for lifetime, but in some it's not. So, and after 18, we talk about the payback trust. Okay. One of the other tools we use in the world of special needs is something called the ABLE account. So an ABLE account, because if we can get that person benefits, and again, the benefit rule is we have to prove they have a disability that stops them making substantial gainful activity. Okay. So if they fall under that, then we have to think about, if they're not going to get benefits, we don't have that advantage. But one of the programs that we have that we can use, it's relatively new, it's called an ABLE account. It is a modification to the 529 Act. So it's a form of a college savings program, but it's not college, it's special needs. So an ABLE account is an account that's set up by the federal government passes. Each state determines if they will have a program. So Florida has a program that only Florida can use. Wisconsin doesn't have one. Illinois has one, and it's part of a consortium of 16 states. An ABLE account is a state-run program where you can save for a person who has special needs as long as they have been not diagnosed, but can prove in some way that they've had a disability before the age of 26. There's a lot of conversation about making that older, but right now it is the age of 26. So we can put money into this account. It's tax-free. The money is to be used for approved disability expenses, which I'll talk about. I talked about the age of 26. There's only one ABLE account per person. So in the world with special needs and divorce, if we're going to use one of these, dad can't set one up and mom can't set one up. The child can only have one. And so we have to agree how that's going to be used if we're going to use this. This money does not count against the child, against their benefits. They can, up to $16,000 a year can be put into the account. And if the child is able to work, they can put another $12,000 a year away. So, and it's capped by the amount that any 529, just like a 529. So a 529 in some states is 450,000. The parents could put up to 450,000 in this. Now, when I talked about child support, most of the states that do allow child support paid past the age 21 or whatever the age may be, 18 in that state. Most of those have a court order requirement to have the child support paid to a special needs trust, not to an ABLE account. They're very clear that the ABLE account is not to use for special needs child support. But this is a great way, perhaps when that whole process is a little, where we may not get benefits, but we might, and we're not sure, that the ABLE account could be used also for gifting if people want to gift. It's a way, and the real rules are that the federal government has these rules on the payback. But what has happened when the parent-child passes away, from the time the account is set up, Medicaid can be reimbursed from that amount in the account when the child passes away. This is a changing tool because now they are allowing a beneficiary to put on these. So if the parent has a second child with special needs, we could give it to the second child as a beneficiary instead of having to pay back to the government right away. This is a moving program. It's constantly changing. When we say it can be used for disability-related expenses, if I ask people who run the ABLE programs, they will say, well, if it betters the person's life, we will consider it an eligible expense. So it's tax-free, it grows tax-free when the money comes out, as long as we have proof that it was used for making the child's life better in the disability world, that will come out tax-free. So people like that, and they say, okay, not only can they do that, but depending upon the state they're in, they might even get a tax deduction for that contribution. So $16,000 can be put into it. Yes.
I'm really sorry. We just have 1 minute to go.
Okay. All right. Good.
I'm skipping my conclusion today because this information is way too important. So for anybody that has questions, stay afterwards, but we're going to give you a minute or two to wrap up, Mary. It's okay if you run a little bit over.
It's okay. All right. I'm almost done. Okay. So agreement, I think I would love to have Georgia comment on this in regard to who's going to handle these responsibilities. So if the child has a special needs, many times someone has to step up to be the guardian in the future, or when the child's 18, they become guardian. Usually it's the custodial parent, or it's joint parenting, joint guardianship that is identified for these things, because those people, these decisions typically can't be made by the child. What do you find, Georgia, in regard to agreement of future responsibilities that are important legally?
Well, one thing that's becoming more increasingly popular in disability rights circles is a concept of guided decision-making, where instead of a young adult giving up or an adult of any age giving up all of their decision-making capability to a guardian, whether a parent or someone else, instead the designated someone, instead of a guardian, a true guardian would be someone who could help guide them, help them think through a decision, but have them more involved in making the decision for themselves. But that, I mean, what in terms of who's making the decision, one of the things the court looks at, it may be divided up, different types of decisions made by different parents, whoever's got the better track record on those, whoever the judge thinks is better equipped. Also, they look at, if a parent is aware of their own strengths and weaknesses, that can be very helpful to show a judge that this person, it's not about their ego or their sense of control. It's more, they're able to say, look, I'm not knowledgeable about so-and-so, so I know I need to seek out someone who can help me with that. So, and sometimes they separate up money and sometimes they separate money and decision-making about other things.
And this is where it's really important to have someone like Marianne and legal counsel like Georgia in the state that you live in, working with you while you're developing a parenting plan. And if possible, to work out all of these details on your own together as parents, because you are really the best qualified to make the best decision for your children. The minute you leave in a judge's hands, as Georgia just mentioned, the judge is going to choose who he or she thinks is best qualified for these types of things. So if you guys can work together at all, if you can't work together in anything else, but you can work together in this for what's best for your special needs child, we highly, highly recommend that when preparing your parenting plan.
Right.
Yep, your parents together for the rest of your lives. That's
I hate to cut this conversation short. It is so important and so fascinating and so helpful to those who are out there. This will be put up on our YouTube page. We'll be putting links up on our site, and we'll be continuing the conversation live for those who are here with us. Thank you so much for joining us. We hate to cut this short, but we are running over. So thank you again for joining us today.
Thank you, everyone. We'll see you next week. Next week's topic, calming the chaos of a high conflict divorce. Thank you all.
Thanks.